All rise. All persons having business before the Honorable Associate Judges now residing over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated and come to order.
Good morning, everyone, and welcome to the District of Columbia Court of Appeals. We have one case on this morning's calendar. It's a special sitting, a summary calendar case that we granted oral argument in, and it is number 23 CO 80 Timothy Parker versus United States. Whenever you're ready, counsel.
Thank you, Judge Beckwith, and may it please the court. Peter Brulin for the appellant, and I'd like to reserve 3 minutes for rebuttal. In Fleming, this court held that the district's homicide statutes required but-for causation, proof that the defendant played a necessary role in the victim's death. But that's not the instruction that was given at Timothy Parker's trial. Parker's jury was told to convict if it found that he was a substantial factor in a fatal shooting. And under that standard, any defendant who played a role in a gun battle could be held guilty of homicide. That is miles away from but-for causation, and the instructional error made a difference here because it fundamentally distorted the jury's fact-finding and required them to convict Parker of a crime that he likely didn't commit. Now, the government disagrees, and they say that the jury could not reasonably have doubted that Parker was involved or played a necessary role in the victim's death, but they can't say that he did so by firing the fatal shot because he wasn't out there when the victim was hit. So the government says instead that Parker was necessary to the entire gun battle. And they have two theories, they say, or two principal theories. They say first that Parker masterminded the entire shootout and then lay in wait for the avenue. But the jury almost certainly rejected that theory because it acquitted Parker of second-degree murder and conspiracy. And that leaves the government's second
Do you
theory.
agree, though, that there's sufficient evidence of that theory? You're not arguing that the evidence is insufficient on that.
That's right, Judge Beckwith. And this court has been very clear that I don't have to come in here and dispute sufficiency. The standard is a reasonable probability of a different outcome, a reasonable probability that a properly instructed jury would have acquitted. And here, I think we meet that standard and then some for two reasons. First, the substantial factor instruction distorted the jury's decision-making. Under the substantial factor standard, the jury had to ask, did Parker participate in a gun battle? And the answer to that is easy. But Fleming requires more. Under Fleming, the jury would have had to find that Parker caused the gun battle. And that in turn would have required them to decide how the gun battle started and why it happened. And if the jury had reached those questions, Judge Beckwith, they would have had overwhelming evidence that the gun battle would have happened with or without Parker. And I'd like to start.
Is it right, though, that they would have had to show or would have had to find that that your client caused the gun battle? Is that the only way you can get to Fleming causation is by, I mean, you just direct causation, your bullet caused the death, or I'm just wondering about the language of saying you caused it. It seems like there are a lot of different, there can be a lot of different causes. As we know, does it have to be you caused it?
So under Fleming, if we're proceeding just under a straight but-for causation theory, then yes, the defendant, Mr. Parker, would have had to play a necessary role. Now, one way of doing that, Fleming says, is if you shoot the victim, and we know that's not what happened here. The other path, and I think this is what the government's theory is, they could tell me if I'm wrong, is that he had to cause the whole thing. So he set in motion the gun battle that led to the victim's death. Now,
Can I just ask a clarifying question? At trial, was there any, did the government suggest that he might have been the shooter, just that the jury didn't have to find that? Or were they acknowledging at trial that he wasn't the shooter.
No, Judge Beckwith, they acknowledged at trial, they came in and they said, look, we're not going to be able to tell you who the shooter was. The government's witness testified that it was somebody from the Avenue. Nobody testified that Parker was the shooter. In fact, Shanita Raja says at page 207 of her appendix, she says definitively Parker was not out there. He was in the building when Buckner got hit. So I think the government's theory has to be that Parker caused the entire gun battle, and they start out with this mastermind theory. And that's based on the testimony from a single witness, Curtis Faison. But there's three reasons that Faison's testimony can't restore faith in the verdict, Judge Beckwith. And the first is the jury didn't buy it. And second-degree murder is the best evidence of that. I think it's the dog that didn't bark, because there's nothing in Faison's story that would have provided mitigating circumstances, heat of passion, or adequate provocation. And so if the jury believed Faison, they would have had to find second-degree murder, but they didn't. They acquitted of second-degree murder, convicted of manslaughter, and I think that shows they didn't buy Faison. But don't take my word for it. Take the government's word, because the last time this case was here in the Parker decision, the government's brief, this is at page 38, said the fact that the jury acquitted of second-degree murder shows that it put, quote, little credence in Faison's testimony, close quote. They also called it thin gruel. And I think the same is true of conspiracy, because I don't see how the jury could have simultaneously believed Faison's story, that Parker gets these guys together, comes up with a plan, and sends them over to attack the Avenue, and failed to convict of
What's
conspiracy.
the theory supporting manslaughter, though?
Well, I think the theory supporting manslaughter has got to be the jury found that Parker wasn't involved in provoking the shootout, or else it would have been second-degree murder. And then Parker is over at the circle. He sees the Avenue guys show up. Clay testifies definitively. They're brandishing their guns are out. And then that's adequate provocation and heat of passion. I think that's what the jury must have found, Judge Beckwith. Now, even if you're any question about the jury's verdict on this Faison story, I think it's implausible on its face as well, because the government has never explained how Parker expected to get a few other guys together and end this years-long feud. Also hasn't explained how they plan to outflank the attackers who are pinning them down from multiple directions. But I think the best evidence of implausibility is that according to Faison, Parker is masterminding this entire elaborate scheme. And then he goes back and he goes to the barbecue with his friend and he forgets to tell Buckner, oh, trouble is on the way. You might want to duck and cover. But even if you're willing to look past that, I think the court still has the granddaddy of all reasons to doubt Faison's story. And that is the evidence that Faison planned to perjure himself and falsely incriminate his co-defendants. And that tallies with what the government said the last time this case was here. My friend, Mr. Saybolt, stood up and told this court that Faison lied a lot. And I don't think, though, that Faison's story should restore this court's faith in the verdict. Now, the government comes back and they say, well, what about this evidence that corroborates Faison's story? This evidence that Parker arms himself and gets people out of harm's way and then posts up for the Avenue. But even then, I think the government needs this court to say two implausible things. The first is that Parker doesn't care enough about these bystanders beforehand to get them out of harm's way before he springs the trap. But then suddenly, after he hears shooting over at the Avenue, he changes his mind and decides to spend precious time getting the neighbors and the kids out of harm's way when he could be marshaling the circle's defenses. The second implausible thing, even if you're willing to buy this idea of an inconsistent mastermind, is that according to Faison's story, Parker sets all of this in motion before he even arms himself. So the government needs the court to say that Parker is sitting around like a sitting duck and the Avenue could show up at any moment. And only after his plan is already underway does he arm himself and take position. So again, I don't think this court should, I don't think that Faison's story can restore faith in the verdict. I do want to say a word about the government's other prime theory, which is that Parker caused the gun battle by firing the opening shot, because I actually think that's exhibit A for how the instructional error made a difference here.
This might be a pretty good point for you to mention or address the government's argument that the trial court found that he was the first shooter, which leads us into the question of the proper standard of review. And the government seems to rely very strongly on a theory that the trial court properly made three important findings of fact to which we should defer as the fact finder, as opposed to your ground, which is that we should essentially ignore them and on our own, de novo, decide whether or not there's a reasonable probability.
Well, Judge Stedman.
Why is the government wrong in what it says? Trial courts normally make findings of fact.
Judge Stedman, trial courts normally do make findings of fact, but if you look at what the government is calling findings of fact here, this is at page 31 of their brief where they talk about those three subsidiary factual findings that you mentioned. They're citing page 17 of the Superior Court's opinion. That's at 641 of our appendix. And what the Superior Court is doing there is it's quoting the government's characterization of the record evidence. So the Superior Court is not purporting to make any findings. It's not talking about credibility. It's not talking about witness demeanor. It's not saying, in my long experience of being a trial court judge, I look at this transcript and I see certain tells that lead me to think that I want to accept Raja on direct examination, not on cross-examination, or I discount what Clay or Hopkins said. There's none of that, Judge Stedman. The Superior Court is just quoting what the government told it in its brief. And right there, those are characterizations of the record evidence. But
Well, that doesn't strike me as perhaps what I thought was the answer, which is that, I mean, suppose the trial court had said, I have very carefully studied the record and I am making on my own a finding of fact that he was the first shooter. Would we then give deference?
Well, Judge Stedman, even there, I don't think this court would give deference because this court is in just as good a position as the Superior Court to study the briefs and study the record and make that legal conclusion about does that amount to prejudice. Now,
Would that be different if Judge Green were handling the 23-110 matter?
well, Judge Beckwith, I think there might be a stronger argument there under the court's second factor in the Miller case, which talks about which court is in a better position more accurately to determine. Of course, that's not the case here. So I think the court could always leave that open if the Superior Court for some reason has a leg up. But to go back to your question, Judge Stedman, even if the court were purporting to make that factual finding, this court has said that when you're making factual findings on a paper record, and this goes to my answer to your question, Judge Beckwith, when it's just a paper record, that's a reason to give less deference to the Superior Court. But here, I think there's even more reason to review de novo. And that is what I said earlier to you, Judge Stedman, which is that the Superior Court was just quoting the government's characterizations in its brief. And this court has said that when the Superior Court is just quoting one party's purported facts, that's a reason for special scrutiny, not for special deference. So I guess what I would say is I have everything I need for this court to say de novo review, except for a decision in this specific context. I've got both Miller factors. I've got this court saying in the context of Strickland prejudice and Brady materiality, which are both analytically identical to the inquiries at issue here. And I've got uniform consensus in the federal courts of appeals that when you're doing cause and prejudice, collateral review, and you're making a prejudice determination, that's a legal question that's reviewed de novo. So again, I think I have everything I need.
Can I ask you, you mentioned the Brady materiality standard, and do we, when we envision what this trial would look like without the erroneous instruction, other than the bare fact that it would have a correct instruction, are we allowed to do, is there any difference between this context and say the Brady context, like Kyles versus Whitley, where the Supreme Court, said they're going to look at what competent counsel would have done in the situation? So when we're looking here, can we imagine competent counsel would have been pushing hard for, with the jury in closing argument and the buff, is that something that we are allowed to consider along the lines of the Brady analysis.
Well, Judge Beckwith, I don't know that I've seen a case from this court where the court does that sort of analysis. The sort of questions that I've seen asked are, given the record that we have, is there a reasonable probability that this same jury with this court sort of sitting, looking over their shoulders, would have had reasonable doubt? Now, I do think it's fair to look at the best proxies we have for what the fact finder would have found. So we quote, for example, Judge Green, the trial judge, saying he would be astounded if the jury believed Faison's story. I think that's fair game because that's the best proxy we've got for what the jury would have made of that. But no, I don't think I've come across a case where the court has said, well, if there were different advocacy, how would it have come out below? But I just want to take a step back and say I don't need that here because I think there's evidence in droves that the jury would have had reasonable doubt. And I do think that this question about who fired first is the best example of that because you've got Shanita Raja testifying on direct examination that Parker fires the first shot. But then she comes back on cross-examination and she admits, well, actually, I don't know when Parker fired in relation to being fired on. And I think that that's game over for this government, Parker fired first theory. But even if you disagree with me there, and this is why we don't need sort of questions about different advocacy, Judge Beckwith, because you've got Jovan Clay, the government's star witness, and Linwood Hopkins both testifying that it was the Avenue that shot first. Clay is definitive. He says that he's there in the circle. He sees 3 Avenue members. He names them, William Spriggs, Raymond Davis, and John Robert Jean Baptiste. They come up the hill. They go between.
Well, I think you do a good job of showing why that evidence could have been disbelieved. But let me ask another question about scope of review. The government says the appellant at the 23-110 level to the trial court essentially relies only on the proposition that Spriggs fired the first shot, that Spriggs was the guy who came up and did it. And then he says in one of his defenses is self-defense. You come up with a lot of good reasons why other theories of who was the but-for person don't work. But none of that was brought up by the appellant at the trial level. In other words, he never said to the trial court, these other theories don't work as well when the government brings them up. Is that a problem?
I don't think it's a
Do
problem.
we say that he preserved all his arguments when he never really made them to the trial court? I mean, it's kind of hard cheese to Judge Cordero to say, well, there are a lot of very good arguments that could be made against the government's theories of but for, but she'll say, I never heard any of those.
Well, Judge Stedman, I disagree with the government about what Parker preserved below. I think Parker did more than enough to adequately preserve a prejudice claim. And once he did that, this court has been clear that he's free to raise any arguments in support of that claim. So Parker comes in the 2310 motion, this is at page 6 of the motion, and he says, look, there was enough evidence to convict under the substantial factor standard. There's not enough evidence to convict or to find that I'm a but-for cause. And the delta between those two standards is actual prejudice. That's exactly what I'm here saying today, Judge Stedman. But it's not just a bare bones claim. Parker fleshes it out because at pages 5 to 6 of the 23-110 motion, Parker cites testimony from Clay that the Avenue comes out shooting. I think that's inconsistent with the government's theory that Parker fired first. Parker also cites testimony from Raja that Spriggs fired the fatal shot. And then Parker argues, my gunshots were not a but-for cause because Spriggs was coming and the gunfight was going to happen anyway. And then he goes on in the reply and he denies that Spriggs and the Avenue came over because of some sort of plot orchestrated by the circle. And Judge Stedman, I think that's more than enough to preserve a prejudice claim, especially under the lenient standard that this court says applies when a pro se litigant comes in. And just to take a step back, because I think this does shed some light on the question of how the preservation analysis works here. In an ordinary 23-110 motion, the defendant comes in and does just that, says, look, under the old standard, there's enough evidence. Under the new standard, there's not. That's prejudice. Then the government comes in and says, well, here's a bunch of reasons why the error was harmless. And normally that's that. And I don't take the government to be arguing, and I could be wrong, but I don't see them as saying that Parker's 23-110 motion was insufficient or didn't do enough to preserve a prejudice claim. Instead, what I think they're doing is saying that Parker's reply brief didn't do enough to address the government's harmless error theories. But just to take a step back, Judge Stedman, the strange thing about that is that the 23-110 governing rules don't contemplate a reply brief. So what the government is really saying is that Parker, pro se, sitting in a prison cell, voluntarily lobs in a reply brief, and somehow they're asking this court to announce a brand new forfeiture rule based on the fact that his reply brief, I guess, didn't do enough to address the government's argument.
I wouldn't quite call it a brand new forfeiture rule, but the government argues this all the time.
Oh, well, Judge Stedman, this
One other, while I'm talking to you, I want to ask you about a factual question. What is your view as to whether or not Parker had emerged from the jamming when Brucker was killed? In other words, was he killed while the jamming incident was going on, or had Parker emerged from that and started shooting again, and then Buckner was killed?
Well, Judge Stedman,
I can't quite tell from the facts as to exactly who killed. And again, it probably didn't really matter from the point of view of the government's case under the old rule.
I think you're exactly right. It didn't matter under the old rule. I was confused about that as well when I approached the case. The only testimony about this comes from Shanita Raja. She says that Parker fires once, has a gun jam, goes under goes into her building, fixes the gun jam, comes back out and fires 2 more times. And she says that's when all of the other gunfire happens. Then if I'm understanding Raja correctly, and again, we dispute that, and Clay and Hopkins, I think, show that that's not what happened. But just going by the government's theory, Judge Stedman, I think the theory is that Parker comes back out after fixing the gun jam. Then there's some more gunfire all around. Then at some point, Parker goes inside the building. Raja's definitive about that on page 207 of our appendix. And that's when Buckner gets hit. So I think that's the order in which things happened. But again, we have testimony from Clay and from Hopkins.
Yeah,
They
it's very hard to
contradict.
tell. Yeah.
And I think the best evidence,
Okay, thank you.
of course, I think the best evidence there while we're talking about Hopkins comes from him. Because Hopkins is on the balcony standing right next to Raja as all of this is going on. And Hopkins is there, he's non-combatant, he lives there with his wife and his kids. He has no part in any of this beefing between the Circle and the Avenue. And he says, I hear gunfire over at the Avenue. I immediately go out onto the balcony. I try and warn the neighbors to get out of harm's way. And then he stands there and he watches, and Shanita Raja joins him. And Hopkins says that he sees the Avenue guys coming up. He identifies a guy in a white t-shirt, 19 or 20 years old, not Timothy Parker because he's 32 at the time. And Hopkins says this person in the white t-shirt, he's the first person who fires that I've become aware of. And the strange thing about the government's theory, Judge Stedman, is that if you believe Raja, then Timothy Parker is standing a few feet below them on the balcony. They're up on the balcony. Parker is on the ground. I visited the Circle this weekend to see just the geography. And these are not tall buildings, Judge Stedman. So if you're standing on the balcony, I gotta think that the Linwood Hopkins is gonna hear 3 gunshots if they're right under his feet. But I do want to go back to
Counsel, help me with this. I know we've already taken you over time. And so you've talked about a lot of different evidentiary theories. One of the arguments you had that I found quite compelling was this idea that as much as there could be different arguments for harmlessness here, et cetera, we can't untangle the knot that occurred. The jury didn't have that in front of them to do themselves. And so just procedurally and practically, we can't say how things would have been handled because there were certain decisions they didn't have to make. Is there anything from that part of your argument that you want to emphasize that you haven't had the chance to get to yet?
Well, Judge Howard, thank you for the question. I think you're exactly right. That is Exhibit A for why this error was prejudicial. And I think all I would say there is just back to what I was saying with the who shot first question. That's a perfect example of it. The jury didn't have to ask that. The substantial factor standard spared them from even getting to that. So this is a 2-month-long trial. There's something like 50 witnesses, hundreds and hundreds of exhibits. And the substantial factor standard told the jury that they could call it a day so long as they found that Parker fired a single gunshot. We know that from Fleming. And so I think if the jury had to wrestle with all of these things, they certainly would have found reasonable doubt. Again, it's not, I don't have to get up here and show reasonable doubt. I don't even have to show a preponderance. We know that from Dominguez Benitez, which we cite in our opening brief. But that is the best argument, Judge Howard, for why the instructional error was prejudicial. And I think what the court could say is, look, there is such a delta between these two standards, and the jury didn't even have to think about cause. And we have serious doubt about the theories that the government is offering. I think that would lay down a marker for future courts and litigants and show what the prejudice inquiry looks like in this context. And we would urge you to reverse, vacate the conviction and remand for a new trial. If there are no further questions.
Thank you very much, Mr. Bruland. Did I say that right?
Yes.
And we will give you some time on rebuttal. Mr. Sable.
Morning, David Sable on behalf of the United States. Judge Cordero found in her order that the government presented extensive evidence demonstrating 3 causal theories. And the one was that Parker was fired the first shot.
Can I interrupt right off the bat? Because I wondered if your wording was intentional. She found that the government presented evidence as opposed to these are factual findings, which seems to be how you argue it in your brief.
Right. And we know, even though the court hasn't said exactly what the standard is here, we know if we analogize to Strickland prejudice or Miller materiality, that the ultimate finding is de novo. But what the court said was, defendant Parker has failed to address the extensive evidence presented at trial demonstrating that 1, 2, 3. If you take those as factual findings, and we think that they are factual findings, the court wasn't obliged to say more. We know the court can make factual findings. Then this court should review them for clear error.
Well,
See,
what-
I think that she was correct in what she said, that, or at least it's arguable that she was correct in saying that Parker has not addressed the 3 grounds on which the government is relying to show but for. And that's why I was asking the appellant. That seems to me to lead into your argument that it wasn't preserved, as opposed to the question of whether or not you really made these findings of fact.
That's absolutely right, Your Honor. This was a pro se pleading. This case has been up here 3 times. It went back down and Mr. Parker wrote his own pro se Fleming pleading in which he said, Weedy from the Avenue crew had a bad reputation and he was coming up there to shoot us no matter what. I didn't do anything. I wasn't part of it. And so that was his argument. And so Judge Cordero was never called upon to really address all the arguments that Mr. Bruland is making here for the first time on appeal. So that's why she said your causation argument fails and you haven't addressed these other things that there was extensive evidence of 1, 2, and 3, our three causation arguments. And I would note also, those are the three arguments that the government argued at trial. The government presented these three theories to the jury. This was the theory of the homicide. This was the theory that was presented. If you read particularly the rebuttal argument, if you read Laura Bach's argument in rebuttal, this is exactly what she argued.
But
This is
again,
what
are
she
you
presented.
making a clear error argument, or are you making a preservation argument? Because I just don't understand this clear error review of fact findings, where the fact findings that you identify as findings are coming to, they're direct quotes from the government's opposition, and where this judge was not the trial judge. She's a judge who took over from Judge Green for the collateral matter. So, you know, and even if they are fact findings, I don't understand how this, and you don't seem to disagree with the ultimate reasonable probability standard. So it just doesn't seem like the best formulation for judging this. We need to ask, you know, whether there's evidence of, you know, there's evidentiary support for reasonable doubt, which, you know, how is there not evidentiary support for reasonable doubt in this record? And why isn't that the question?
Well, ultimately, it is the question. Ultimately, the question is prejudice, but we don't think that the court is looking at it de novo through. Obviously, the ultimate question is de novo, but we think that there are factual findings. But we do think, Your Honor, under any standard, the evidence was extensive that of but-for causation, and their burden at this point, under the cause and prejudice standard, is to establish. Their burden is to establish a reasonable probability that a properly instructed jury would have acquitted. That's what they've got to show. And we have extensive evidence that shows that the jury considered these three theories. And we think the evidence establishes that but for causation here.
So
Yeah,
Counsel Lynn.
although I maybe won't be able to convince you about the factual findings. I do want to say one thing about it before just moving off of it, which is that Judge Glickman wrote an opinion just 2 years ago in Henderson, where he talked about it's not just that the trial judge had the opportunity to see the facts and the witnesses. It's also the idea we also defer to trial judges because they are experienced fact finders, and de novo review by an appellate court is unlikely to produce significantly more accurate factual determinations. Additionally, permitting appellate courts to share more actively in the fact-finding function would tend to undermine the legitimacy of trial courts in the eyes of litigants, multiply appeals by encouraging appellate retrial of some factual issues, and needlessly reallocate judicial authority. So again, we don't think the standard matters, but we think
He's talking about that in the context of someone who hadn't seen the witnesses. Is that what you're saying? And he's saying it's still important because they're trial judges. They know how to judge facts, but doesn't that clash? I mean, you know, Judge Glickman wrote it. It's in a case, but we also have a lot of cases talking about what it's okay for us as an appellate court to look at, you know, in the same way the trial judge would, like video and, you know, transcripts. And
this court has been moving towards de novo review in lots of areas. I think it's not a great idea, but that's true that this is where the court is going. I think Judge Glickman laid down a marker in Henderson saying, hey, I think we need to think carefully about it. But you know,
Judge
again,
Judge Cordero didn't look, you know, Mr. Faison in the eye. And, you know, I like if she's whatever credibility determination she's making, why couldn't we make those just as well? And I'm not, you know, and one might ask, why does it matter? Unless you have just overwhelming evidence, because I'm not sure how you can get to the point where you know, how do you show that the jury was not spared from, you know, resolving key factual disputes that they would have had to decide if they had the but-for causation requirement?
well, again, we think under either standard, de novo or clear error, we think that the appellant can't make their burden. We think that the evidence was so extensive. Again, it was a 3-month trial. There were over 60 witnesses. There were over 500 exhibits. There was extensive evidence about on each of these theories. And if I could turn to that, I certainly will. We know that, first, on the question of Shanita Raja. Shanita Raja was a witness. She was the only witness who saw Parker out there that day at all. She was the only witness who saw him firing. And most of the defendants urged the jury to credit Shanita Raja because she thought that the guy on the hill from the avenue was the one that killed Buckner. But what she said was, Parker got the gun, crossed the courtyard. And by the way, the courtyard was empty at the time of the shooting, except for Buckner. And there's a surveillance video that shows this. And this was argued to the court. The courtyard was empty. The party goers were gone. He gets the gun. He posts up in front of 610, which is the building on the left. He's brandishing the gun, which this court has said in Roy and Fleming is but for causation, can be. So he's shooting, he shoots first, he brandishes the gun, and he sets it in motion. He's standing in front of 610. Weedy appears on the hill. Now, Linwood Hopkins is standing next to her, but he never sees Parker. He doesn't see Parker at all. Yes, Parker's below him, but he's looking way up the hill at Weedy, and he sees Weedy.
But I think the problem with that is you said it can be, but for causation. Like, why don't we need the jury to decide whether, for example, it doesn't matter if Mr. Parker shot the first shot because the Avenue people were coming from every corner. They were going to shoot, they were responding to something. They were coming, they were going to shoot whether Parker was even there or not. Like, why do we just take the jury out of that? They can't decide that because we so know that the fact that he shot first, which is the subject of some, conflicting evidence, that just does it for us.
Well, there's the extensive evidence, which we try to set out in the brief, and I wanted to address here. But then there's also the self-defense argument. And I would make a point, and I know that you personally, Judge, you in Edwards, I think you wrestled with Fleming and self-defense. But one of the things is, in this case, Mr. Brulin makes, I think, a good point about, well, the jury could find you didn't act in self-defense because you failed to retreat. But that none of those other exceptions to self-defense applied here. What the government said to the jury was, you don't get to sentence, this is on page 131 of the July 2nd argument. You don't get to send someone down there to shoot up another neighborhood, wait for them to come back and then say, oh, my bad, self-defense. That's not the way the law works. In these facts, Your Honor, in these facts, given the facts that nobody was challenging about the way this thing went down, the rejection, the finding by the jury that there was no self-defense for Parker was very close, if not tantamount to a finding that Parker was a but-for cause, that he had provoked the shooting upon himself, whether it was by ordering the shooting in first court, whether it was by brandishing and pointing a gun that caused the other side to
Again, when
shoot.
you say it was very close to, like, maybe a jury would have, maybe it wasn't. This sounds a lot like the judge saying one could look at this evidence and reasonably infer certain things, but that doesn't mean that this jury would have.
But Your Honor, I don't have to convince you beyond a reasonable doubt that a jury did this. He has to convince you that there's a reasonable probability the jury would have acquitted. I see those two things as different. Even if you think there are some chance that the jury would have acquitted here, you have to think it's more likely than not that the jury would have acquitted. That's very different from saying, oh, well, maybe they would have acquitted.
I mean, do you think the government would have charged this case post Fleming? Is the government bringing cases like this post Fleming? It seems like Fleming makes these much more difficult to present to a jury. And, don't you need to incorporate that into your reasonable probability argument?
I think the government would have charged the case the exact same way and would have presented the evidence the exact same way. If you look at the first court, the idea that he set the chain in motion, you have not only the fact that Parker and Fortson tell the three younger guys to go down there. You have the fact that these were two senior members of the crew who took younger members of the crew under their wing. The characterization of him as not being part of the circle is just not right. There's lots of quotes from Javon Clay. He talks about how he's always encouraging these guys. Don't let the Avenue guys come up here and start shooting. You go there first. And that testimony comes from witnesses besides Faison. You go there first. Don't let those guys come up here and start shooting. You go down there. He's always telling the younger guys to do that. And he did that here. And that's why he knew that this was coming. He knew it was coming, and he shooed everybody out of the courtyard, and he armed himself. When that does bring us to a second theory, Your Honor, in Judge Glickman, in Roy, and in Fleming, and just common sense. I know if I stand there with a gun and I'm pointing it at this person over here, and that person pulls a gun and shoots me, I'm a but-for cause. I pointed a gun at you. You know, I made you think I was about to shoot you. I'm a but-for cause. It may be that you were also a but-for cause. You were walking up here, you were planning on doing something. But if I point a gun at you, I'm a but-for cause as well. And then it gets us to our third theory, which is the Shanita Rogers testimony, and she was the only witness who saw Parker out there. And notwithstanding the other testimony, the jury almost certainly credited her testimony that Parker fired the first shot, which again would be but-for causation. And I want to say, Your Honor, the idea that other people could also be but-for causes of this does not excuse Parker's conduct. We know Mr. Brulin makes an argument about how if Fortson, for example, also said, go down there and do the shooting and then we'll set the trap, then that excuses Parker. But that just isn't the case. If you look at this court, if you look at Barrage and you look at some of the other cases interpreting Barrage, it's a Lefebvre. We know that if two people shoot somebody at the same time and they both kill, both of those bullets were sufficient to kill them independently and concurrently, they're both but-for causes. It may be that if the one didn't shoot and the other shot, the person still would have died. But the courts have said that's still but-for causation.
I
So
just don't understand why we can't contemplate a jury that is thinking of this differently than you are, would just see the facts as not supporting a first shot fired by Mr. Parker or Mr. Parker masterminding the whole thing. And I want to pose to you the question that I asked your opposing counsel, which is, can we consider, like in the Brady context and Kyles versus Whitley, when we're thinking about this, can't we think of it as in a trial where the correct instruction was given, different things would happen, like the competent counsel would be trying to downplay things or, cross and impeach things that support but-for. It's not like we just take as a given every fact that's out there that seems like it supports but-for.
I don't know the answer to your legal question. What I do know is that I believe that if the standard had been different, and this goes to your question as well, Judge Howard, the case would have been tried the same way. The question that everybody was arguing about at trial was, who fired the fatal shot? Do you have to fire the fatal shot? What did each person do? What did they do?
But the prosecutor in closing says, don't worry about that. Don't worry about that. Don't worry about that.
And
If it were a Fleming instruction, they'd have to worry about that a little. They have
Not
to-
really. I mean, it
Really?
would be nice. Again, it's always nice when your guy fires the fatal shot. You're done. But you don't need it for but-for causation. And we know that from Fleming and Roy. We know, again, if I set it in motion, I'm a but-for cause. If I brandish the gun and cause you to shoot at me and I shoot back, I'm a but-for cause. And we know that if I fire first, I'm a but-for cause.
You act like Fleming was an affirmation of Roy when it was basically overruling Roy.
I think in many cases, a case that's where someone's convicted under gun battle, under Roy gun battle, they will not be able to meet the but-for causation standard. Clearly, we know that that's got to be the case. But when you look at this 3-month trial and this evidence and these theories, the jury did wrestle with these questions. The jury was Read the rebuttal argument, read the closing argument. You will see these very questions. We didn't make these theories up on appeal to be fancy because of Fleming. These were the theories that the government presented at trial. And I think for that reason, your question is a little bit academic, Your Honor. I think these questions were joined. And that's why they can't meet their burden. That's why they can't show a reasonable probability of a different result.
And just so I understand, you're saying we pretty much know the jury already found but for causation.
Well, I mean, yes, on these facts, to convict him of murder of any stripe, they found that he was a but-for cause. It wasn't enough for him just to be out there. No, because the way he was out there, the whole evidence, nobody said that he just wandered into the gunfight and started shooting. You know, that might be Roy, but not but-for. Nobody said that he had a hand in this or participated or is a substantial factor in some way that was less than but-for causation. He was guilty or he was not guilty on the theory that he did the three things I've been trying to hit home here. And if he was guilty, then he was a but-for cause. And if he wasn't guilty, then he wasn't. There was no, oh, well, he's kind of guilty because he only did a little bit. The theory was he ordered it, he posted up, he had his gun, he fired the first shot. And if they believed any of those things, then they convicted him. If they didn't believe it, then it's hard to see how they would have convicted him. That's the argument that I would make to you, Your Honor. If I could just
So your argument is that the jury must have necessarily found that one of your three arguments for but-for, they must have believed one of the three, otherwise they would not have convicted him. Is that your point?
that is my argument, and it's not.
They would have.
It's not the standard.
jury must have either thought he fired the first shot, or that he lay in wait, or that he, what's the third one?
Fired the first shot. Armed
Or
himself
the
and lay in wait.
conspiracy. They must have believed one of the three. The government says, or the appellant says, you can't believe the conspiracy thing. They acquitted him on that. You say, oh, but the conspiracy theory was bigger. So forget about the conspiracy theory. Lie in wait, kind of doubtful. So it all really comes down to your, I think, saying the jury must have found that he fired the first shot. Otherwise, they wouldn't have convicted him at all. Is that really true? Under a substantial contribution?
The three theories are not quite what the court just said, Your Honor. The first was not conspiracy, but that we ordered the young men to go down there and set it in motion. The conspiracy was a 2-year object of conspiracy.
Yeah, that's what you said.
And it was, and Faison took the stand and admitted to, for example, killing Melvin White, Dirt Dog. There were a lot of, the overt acts were well established. The idea that the jury acquitted on the conspiracy does not reflect on Faison. The court wasn't, even if the court wasn't obliged to reconcile those, but the conspiracy mostly had to do with other witnesses more than Faison. So the conspiracy does not, in our opinion, bear on the idea that Parker and Fortson sent these young men, the young guys, down to first court to start the shooting. But that's theory one. Theory two is not just lying in wait, but arming yourself and lying in wait. And again, I think we have to admit, if you put it in your pants and nobody sees the gun, that's not very provocative. You've got to be standing there as he was with the gun in his hand and the cloth over the gun, you know, waiting for somebody to come down the hill. There were 3 little entryways into this circle, and he was guarding the one. And then the third is that he fired the first shot. And people credited Raja and it's hard to see that they could have convicted Parker without crediting Raja. She's the one that said Weedy is the one that killed Buckner. Parker wasn't inside, by the way. He was just under a breezeway fixing the jam when Buckner runs over.
But I don't understand this necessarily. So are you saying that if the jury had not believed that he fired the first shot, they would have acquitted him? I mean, that's
No,
pretty astounding to think under the substantial contribution theory.
no, Your Honor, I'm not saying that, because even if they didn't think he fired the first shot, they could have thought that he was responsible for setting the whole thing in motion, or they could have thought that he was responsible by standing there with a gun waiting for Weedy to come down the hill. And again, we don't have to show that the jury necessarily found this. We just have to show, they have to show a reasonable probability that the jury would have acquitted if the instructions had been different. I see those two things as different. You know, I do believe that the evidence, we would have presented the same evidence and it would have gone the same way if we were instructing under Fleming.
Can you say a little more about your lie and wait theory and how that supports a but for conclusion?
Yes, Your Honor, thank you for the question. In Fleming, this court said that bringing an armed group in search of another person or brandishing a gun at another person would be but-for causation. And then in Roy, Judge Glickman, concurring in part and dissenting in part, said that he agreed that it would be murder if the jury, and so Judge Glickman, as I recall, was not supporting the substantial, he's did not agree with the gun battle theory back in Roy. Said that if the jury had found that he approached the car pointing his gun at his opponent but did not fire the fatal shot, he would also be a but-for cause. So I take those to mean, again, it's common sense. If I stand there and point a gun at you and you fire back and our gunfire somehow kills a third party, I'm a but-for cause. I'm a but-for cause because I pointed the gun at you. That is so provocative that I have caused the gunfire to happen. Again, I think
So you're
that's
equating lying in wait with pointing a gun at.
no, because no, lying in wait is a word that somehow become what Parker did. No, lying in wait in and of itself isn't, I don't know what lying in wait is. Lying in wait, standing there with a gun, pointing it at somebody, that is what Parker did. That's what, and what Judge Cordero found was armed themselves and lay in wait. So that's why I say armed themselves and lay in wait. And the testimony, of course, was he didn't stand, he stood there with the gun in his hand with a little cloth over the gun.
How unusual would that be in a neighborhood adjacent to, well, two adjacent blocks in a neighborhood where, you know, we've got a beef here, like, and they regularly fight, try to kill each other, et cetera. Like, isn't it unusual that he would have had a gun or even that he would have had it out and ready if he was near one of the 3 entryways?
No, it happens all the time. That usually, I'm sorry, what are you asking about being what's unusual? Having a gun, having the beef, or?
Well, in these circumstances, it doesn't seem to be particularly notable to me that he had a gun, or even if he attempted to cover it, that he was sitting there. And you're talking about pointing it and at the risk of expanding this into a further compound kind of question. I wonder how much the reputation of Spriggs, who he saw coming, matters to all this too. Like, is it just this clear on the record that he was just sitting there, he knew somebody was coming and he was waiting to get the drop on somebody, versus I deal drugs in a dangerous area, there's 3 discrete entrances, I'm going to be armed anyway, and I'm at least trying to hide it. Like,
the testimony was he was on the other side of the courtyard. He left, he went somewhere, took a gun that was secreted somewhere, put a little cloth over it, walked through the courtyard, told everybody to get inside. And then he stood in front of the building on the left-hand side, which was 610. But it is true that other people knew when they heard the shots in the buildings behind in First Court, people knew that something was coming because there had been 13 shootings between these guys. Everybody knew this. This is why Shanita Raja walks out onto the balcony and starts calling out to people, everybody go inside, because they know something's about to kick off. Buckner was drunk, and so he didn't go inside. I don't know why he didn't go inside, but he was intoxicated. So whether we think that behavior by Parker corroborates the idea that he set it all in motion. But if you don't think that, it certainly sets up the idea that he knew something was in motion, even if he didn't set it in motion, and he was armed and waiting for it. And again, that's where the self-defense instruction comes in. If you thought he had a right to self-defense there, then they wouldn't have convicted him at all. But he clearly provoked that. He could have gone inside. He didn't go inside. Nobody said that. He stood there with a gun, waiting for the guy to come through down the hill. And he fired at the guy when he came through the hill. That's but-for causation. That's what the jury was asked to find. And not but-for causation, but those are the facts that the jury was asked to find. Thank you, Your Honor. It's a conversation without words.
Yeah.
And that's why we believe that our opponents cannot show a reasonable probability of a different result in these particular facts, given this particular case.
Thank you, Greg.
Why do you think the jury necessarily found that it was not self-defense?
They were
No,
required.
I asked the wrong question. Why do you think the jury found that could the jury have found that it was imperfect self-defense? Why did they convict him of voluntary manslaughter instead of murder? That's what I was trying to figure out myself. What did the jury necessarily think must have happened?
When Mr. Brulin said that, when he was up here, I was trying to remember in the closing argument if anybody said that he actually but unreasonably thought that he was acting in self-defense. I don't remember any mention of that.
Well, I assume the second, didn't the voluntary manslaughter instruction include that in incomplete self-defense?
Right, it's possible that they did that. I mean, certainly, as somebody who's been trying cases and gang cases in DC Superior Court, I just think this behavior, the jury didn't feel like it felt like first-degree murder. They felt like a bunch of us are out here shooting guns in a crowded area. It was really reckless. It was really stupid. And we got somebody killed, but they didn't really feel like it was first-degree murder kind of behavior. That's not a legal argument. That's a street justice argument. And that's why I think they ended up where they did. But they did have to reject the self-defense claim. I guess you're saying that he.
I'm not saying much of
But Your Honor,
anything
even
except-
if they made that self-defense finding, I'm trying to think, how does that affect the causation? He's still a but-for cause. Right? Because maybe he thinks I'm not provoking this on myself. So it's imperfect self-defense, but he's unreasonable in that he did provoke it on himself. And because he did provoke it on himself, then he is a but-for cause, right? Isn't that the right legal analysis?
Well, maybe I have this wrong, but the jury gets the wrong instruction. But nonetheless, if the jury found that one of your three theories of but for, if they necessarily found that, then I suppose there's no reasonable probability they would have come out differently because they already found that fact.
Yes.
So that's what I think you're arguing, is that the jury must have found, or most likely, maybe you only have to say most likely they found one of those three.
Yes. Yes. When you say
So then the
necessary, I get
question comes,
scared.
then it
Yeah.
just comes to a question of was there sufficient impeachment of the testimony, or were there other factors involved which cast doubt upon whether or not it's more likely than not that the jury found that?
Yes.
Yeah.
Yes.
Okay. I guess that's where we are.
I think so.
And so if we felt like the way this is set up, we just can't reasonably parse the jury at all here, or to an extent that would leave us confident in anything, is it your position that that then means things should stand as they are? Or would it be that we should send it back and see what a jury would do?
It depends on what you think of the evidence, and it depends on what you think of Judge Cordero's findings.
See, my problem with.
Because I,
Go ahead. No, finish.
when the court looks at instructional error in this context, sometimes it can parse the jury and draw inferences from that, and that helps you in your analysis. But if you can't, that's not the only tool in your toolbox. You have the evidence itself. You might have findings from the trial court. We think you do, maybe some, maybe you don't. And we have the way that, well, those are the basic tools. And I would urge you again to look at the closing argument and look at the way the case was presented, and maybe that would help you think about the evidence and what the jury's findings actually did mean.
See, I got the impression from your brief that you really are relying on the trial court's findings that the jury so found, rather than arguing it's so nonetheless. But anyhow, I get your point. I just want to ask one other kind of technical question, because I think we understand your position pretty well. This technically is not a 23-110 ruling, in this sense that the government says to the Movant, you can't even bring this 23-110 on the basis you're bringing it because you have not shown cause and prejudice. So technically what we're looking at is not the substantive decision on the 23-110, but rather on the question of whether or not he can even bring the 23-110 by showing cause and prejudice. So what I'm wondering is, the argument is made that we should somehow reverse the trial court and say that there should be a new trial, as opposed to saying he can bring his 23-110 because he's shown cause and prejudice. Now you, trial court, go ahead and rule on his 23-110, which is a different proposition than at least what the appellant's asking for. And I'm wondering if what does the government think we should do if we agree with the appellant that cause and prejudice has been shown? Because technically that
That's
only
a great
gets him
question.
to the 23-110. But yet, what's the point of having any, if we say, yeah, there's prejudice, what's to be done? Because everybody agrees that it was cause.
We don't, but Judge Cordero said it was. But yes, that's exactly right. Is there a procedural bar, cause and prejudice? Specifically, was he prejudiced, and should he be able to bring his claim? And if the court finds that he was prejudiced, it's not exactly the same thing as litigating his underlying 23-110 claim. So I do think it would be permissible to send it back to Judge Cordero and allow the presentation of the collateral claim. That would be, and then in that case,
But what could possibly be different if we determined that prejudice was shown and there was reasonable probability of a different outcome? How could the trial judge reject the 23-110?
well, I think if you don't defer to trial court factual findings, it probably doesn't make any sense. But if you do defer to trial court factual findings, if you view Judge Cordero as somebody that you want to have read, which she probably did already, 3 months of trial, and have sift through it and evaluate it, make factual findings and rely on that, review that for clear error, then I think it does make sense. But if you don't, then it probably doesn't make there's no point to it.
What makes you think she read the whole transcript? Because the order, relies heavily upon our decisions and the government's brief. It doesn't really even cite to the transcript.
I don't know. I
Okay.
just think she's a very thorough jurist. I mean, she's not required to say what she did or what she didn't do. Thank you.
I mean, the thing is, we say over and over again, 23-110, discretionary decision by the trial court. And then we come to something like this on prejudice and we say, oh, no, this is de novo. So
Well-
I don't know if there's any discretion left in the trial court.
I do think,
Once we decide the cause and prejudice issue.
I do think that that is a concerning issue, and I think maybe having read her opinions, Judge Beckwith and I don't agree on this, but I think that the standard of review is really important. And the standard of review says trial court judges are really good at making factual findings. We want them to do that. They're a coordinate branch of the criminal justice system, and we want to rely on them. And that to the extent this court starts moving in the direction of de novo review in various areas, it gets you into a situation where you're duplicating their work. And
But it depends on what kind of question it is. That's coming up. It might be a fact question, it might be purely discretionary kind of question. This is a legal question, harm, and as your opponent points out, the government even said that in its opposition before Judge Cordero, that it's purely a legal issue. I think you kind of,
we said prejudice was, Your Honor. We didn't
Okay.
say factual findings, prejudice. We all know, right? We know what Strickland prejudice is. We know what Brady materiality is. We've all read Miller. We know how the court parses those standards of review. This is cause and prejudice, which might be similar. And we don't think it really matters, but it is true that the Supreme Court, when it talked about cause and prejudice, made the prejudice standing here higher. It seemed to be higher, and the circuit has said it's higher than Strickland prejudice. We know that this court has said Strickland prejudice in ineffectiveness situations is the same as cause and prejudice, but this court has never addressed this particular situation. I don't think it needs to do so here. But again, we think it's a legal conclusion as to have they shown a reasonable probability of a different result. However, there are underlying factual findings. And again, I don't think that Judge Cordero was obliged, certainly in this case, to say, oh, by the way, I've read the whole transcript and I've done this and I've done that. She just was making the three findings. And we don't think it matters, but we do think the court should defer to those. Thank you. There's no further questions to ask the court to affirm. Thank you.
thank you very much. Mr. Bruland, we will give you 3 or 4 minutes. Let's go with 3, and if you need more, we'll take it from there.
Thank you, Judge Beckwith. I'd like to start with your question about the standard of review, and Judge Stedman, I hope I'll be able to get to your question about self-defense and the remedy, what happens from here. Judge Howard and Judge Beckwith, I'd also like to address your questions about brandishing, and I hope I'll have a chance to answer those. Judge Beckwith, on the standard of review, I do think this is de novo all the way down. I've never seen factual findings that look like this, where the Superior Court doesn't purport to be making factual findings, doesn't weigh, for example, Faison against anybody else, or Clay or Raja, or talk about any of these things. I'm not here dickering with what the Superior Court wrote, but we point out in our brief, it conflates Spriggs with Raja. I don't think this is the sort of case where this court looks back and says, boy, we really need to defer to the Superior Court because the Superior Court has used its expertise in credibility and demeanor. And this is something that's a plain case for clear error. Judge Stedman, you asked about self-defense. Now, I haven't prosecuted gang trials in Superior Court, but I do know the record in this case. And what I would tell you is that the jury could and probably did reject self-defense without finding that Parker provoked the shooting. And Raja says, this is at page 184 to 85 of our appendix, that Parker is out there and then he goes back into her building and then he comes back out. So there's no duty to retreat. But when you go into safety and then you come back out into harm's way, self-defense is off the table. That's what the prosecution said at closing. They said Parker retreated and then he returned. That's why you should reject self-defense. I think the jury believed that, but the prosecution never asked the jury to reject self-defense because Parker fired the first shot or somehow masterminded the attack. Now, Judge Beckwith and Judge Howard, you asked about the brandishing, and I heard Mr. Sable say a number of times that Parker was out there pointing a gun. I didn't hear him cite a transcript page for that, and I didn't see a transcript page in his brief where he's talking about brandishing. There is testimony from Clay that the Avenue comes out with their guns out, but I don't see anything saying that Parker caused the gunfight because he's pointing at his gun at the Avenue. And even if he had, Judge Howard, that goes to your point, which is, I think, the core of the prejudice here, which is that even if the jury had found that Parker is out there waving his gun around, they still would have had to ask whether that was necessary for the fatal shooting. Here, I think we have evidence in droves that Spriggs and the Avenue were going to come with or without Parker, whether he greeted them with bullets or balloons. So I don't think this sort of lying in wait and brandishing theory has a basis in the record. Judge Beckwith, you asked a question about the standard, and I think that's very important here because I heard Mr. Sable say something like, well, we have to show it's more likely than not. That's not the right standard. Dominguez Benitez, the United States Supreme Court decision we cite in our opening brief, says that we don't have to show it's more likely than not. This is not a preponderance standard. And this court has also been very clear. The question is not, is there sufficient evidence to convict? The question is reasonable probability. And I would say if there's any question, look at pages 99 to 100 of the Perez decision by this court, where this court says, look, we know there's a whole lot of evidence that Robles Benavidez went out and was probably guilty there, but we still think that there's a reasonable probability, there's prejudice here. Sure, I will grant, the court said, that there's more than sufficient evidence to convict, but the court still found prejudice. That's the standard we have to meet. And I think we've
Is
more than.
Perez is a Brady case, is that right?
That was a case about Wilson Bay, Judge Beckwith.
Okay.
So that was an aiding and abetting case. Now, I also heard my friend, Mr. Sable, talk about a statement that Parker would made, and that's in the same analysis. So if you look at the Wilson Bay case, you have testimony there that the younger sister, Marbury, comes in and says, well, I'm going to kill that so-and-so. And the government comes into this court and they say, well, look at that. That's evidence that the younger sister could be convicted as a principal of first-degree murder. And this court said, not so fast. There's evidence on the other side of the ledger. And just that statement, just these suspicious things, that's not enough to restore faith in the verdict. Now, I also wanted to say a word about.
Wait, just a moment. Did you say that we have rejected the concept that it has to be more likely than not that they would have acquitted?
Judge Stedman, that's the Supreme Court, I believe, in the Dominguez Benavidez case. That case says the prejudice question, it's not, can the defendant come in and show it's more likely than not that a reasonable jury would have acquitted? That's not the standard. It's less than a preponderance. And this court has said in Perry, and we cite that in our opening brief, Judge Stedman, this court has said in Perry and Perez, we're not doing sufficiency. The question is not, has the government put out enough evidence to justify the conviction?
Oh, no, I mean, for sure, that is not, that doesn't settle it. It's not a question of whether there's sufficient evidence for the jury to convict, because I think here there clearly is sufficient evidence for the jury to convict if they believe this and that and that. So what I'm trying to figure out from what you're saying is, all right, if that's not enough, what is the standard? I always thought it was pretty much more likely than not, but maybe I'm wrong.
No, Judge Stedman, that's not the way I read this court's cases. I think the best place to look here would be the Perry case and the Perez case that we cite in our opening brief. Those both had to do with the instructional error that this court found in the Wilson Bay case. It was about aiding and abetting.
Yeah.
And the defendants in both of those cases come in and say, look, we were prejudiced because we got the bad aiding and abetting instruction, reasonable probability of a different outcome for a properly instructed jury. And the government comes in, just as they are here, and they said, what are you talking about? There's evidence that you were guilty. In Perry, they said you're guilty as principals. In Wilson Bay, or I'm sorry, in Perez, the government comes in and says, well, look at all of this evidence that Robles Benavidez would have joined the fight and had the mental state anyhow. And this court said, sure, we see that there's plenty of evidence here. In fact, in Perez on page 100 or page 99, the court says, without a doubt, there's enough evidence to find that they were guilty of first-degree murder, but the court still said prejudice. And the reason the court said prejudice, Judge Stedman, was because the evidence that the instructional error made a difference, that was enough to overcome society's interest in finality and say that we can't be confident in the verdict. That's what the court has said, and it's not more likely than not.
It's really astonishing, isn't it, that the reasonable probability that the outcome would have been different is a phrase that we use over and over and over again. And in so many different contexts, and you'd think that it would be fairly well settled as to whether or not it's a more likely than not standard, and if so, which way it's more likely than not. But
Well, I
you're
think
saying it's sort of settled by these two cases that you cited.
that's right, Judge Stedman. I'm saying it is settled. It's less than more likely than not.
It's less than more likely than not.
Exactly. So in Perry, so Dominguez Benavides, the
Well, if
Supreme
it's
Court.
less than more likely than not, that's going to be true for Strickland. It's going to be true for all these different things, unless the more reasonable probability standard has certain nuances that vary depending upon the context in which the question is being asked,
Well, I don't know that it varies based on the context.
which
Judge.
apparently is true, for example, for per se error, for plain error.
So I will give the government this in the limited sense that we don't do per se error on collateral review. That's Frady. So
Yeah.
I think Frady is a good example. The defendant in Frady comes in and says, look, the instructional error made a difference here. It required the jury to presume malice. That took
Yeah.
manslaughter off the table. And the Supreme Court says, no, we're not going to do that. You need to give us a colorable claim that it would have made a difference. And so that's what these cases are talking about. The Supreme Court in Frady said, well, this would be a different case if the defendant came in and had a colorable claim that he could have been convicted of manslaughter and wasn't just a hired assassin who goes and tries to kill Thomas Bennett. And this court has said the same thing in Perry, where it talks about, well, there's a colorable argument here. I did want to say just a word to you, Judge Stedman, to try and convince you that the preservation argument is a little stronger than your question suggested. So I think we give the court three ways to reach the merits. The first is, and I think the easiest, is just to say the government doesn't deny that Parker adequately preserved a prejudice claim. And once he's done that, he can come in and raise new arguments on appeal. And Judge Beckwith, that's your opinion for the court in the Miles case. So Miles is talking about reasonable suspicion. The defendant comes in at the suppression hearing and says, I didn't run. What are you talking about? And then at trial, he says, I didn't run from police. And then he comes into this court and he says, well, actually, I did run, but I was provoked. And the government says, well, you didn't say that before. And your opinion for the court runs through the preservation analysis. And you say, look, the overarching claim is reasonable suspicion. You can come in now and raise a new argument. That's Miles. I think it's our best case there. And I have to say, I think it's a little rich for the most powerful, best represented litigant in the country to come in and say, because Parker filed a pro se reply brief from prison that didn't adequately address all of our harmless error arguments, somehow this court should announce something it's never done before, which is if you file a voluntary pro se brief in a 23-110 proceeding, you'd have to come in and argue with two hands tied behind your back. Now, the last thing I would want to say, unless there are any further questions, is just a word about the remedy, because I think you asked about that, Judge Stedman. My understanding, and I'll grant this is from the Judge Edwards treatise in the federal context, when you're talking about things like Strickland prejudice, if you satisfy cause and prejudice, then the substantive standard is going to be subsumed in that. So if I convince you that Parker was prejudiced, then automatically there will automatically be actual harm, and that's enough to trigger the remedy we're asking for. So just to say a word about that remedy, Parker's now 46 years old. He's been in prison for the last 13 years. If we're right, then he's served out his sentence long ago. So I would ask if the court is going to agree with us that you say in the opinion that time is of the essence, because he's going to be released in January 2026. So there's a limited window for effectual relief. We would ask the court to vacate the conviction and remand for a new trial. Thank you.
Thank you very much. Thanks to both of you for your briefing and your arguments. And Mr. Brulin, thank you in particular, and your firm Sidley and Austin for being willing to take on this case and take it so seriously. We will take this case under advisement and we are adjourned.
All rise. Honorable Court, stand adjourned.